All right, welcome to the first chapter of uh, or module four, module four, chapter 12, where we dive into um, corrections. So far, we have looked at the early stages of our criminal justice system. We've looked at law enforcement and how it conducts its business, and then we've looked at the court system and all the appropriate players there. Now we're going to take a look in this module at corrections, which is the back end of the criminal justice system. And specifically for chapter 12, we're going to take a look at not incarceration, but we're going to take a look at probation, intermediate sanctions, and restorative justice. Specifically, we're going to talk about the history of community type sentences. We're going to talk about variations of probation, the rules of probation, how probation services are administered. We're going to talk a little bit about risk classification and legal issues related to probation. We're going to evaluate the system's effectiveness, and we're also going to talk about two developing processes, which are intermediate sanctions and restorative justice. Probation is not a new um, concept, though many of us may think it is, but community sentences were born from the concept of judicial reprieve. In other words, a judge deciding to be lenient or a judge deciding to give someone another chance. It's actually a common law practice that allows judges to provide another sanction instead of simply sending someone to jail. And it gives a judge more options and a better ability to positively impact not only the offender's life, but the community as well. In many cases, we see this as similar to recognizance. We talked about recognizance bonds, in which an offender promises to report to the court as necessary should they be let out of jail. And to a certain extent, recognizance and probation allows offenders to not be punished by a jail sanction, provided that they reform, provided that they change their life and change the aspects of their life that contributed to that crime being committed. In the United States, we first formally saw probation in 1878 when John Augustus convinced the Massachusetts legislature to pass a bill that formalized probation as a service and created the position of probation officers for the state. This was federally adopted in 1925, and then within a very short period of time, the states who had yet to adopt the practice began to do so. There are different types of probation, which is necessary because there are currently about 4 million people on some form or another of probation across the country. This is not a number that's going to decline. This is a number that will, in fact, grow over time. Over time, we have seen more and more criminal statutes that are developed and passed by state legislatures. And because of that, when we have a bigger criminal code, we will have a larger group of offenders that we're dealing with on a regular basis. So without probation, the prison population would flat be out of control. Overcrowding has been an issue for a long time, even with our probation system. Would we take it away? That would not work. At a basic form, most probation is offered as supervised, in which they report to an officer on a regular basis, or in some low level cases, we offer what's known as unsupervised probation, in which, as long as they pay their fines and fees that they've been assessed and they don't end up in front of the court within a specific period of time, they've successfully completed that probation. Probation comes with strings attached, known as conditions or rules that are typically mandated by a court order. In most cases, the rules related to probation have been handed down by the chief judge of a district. It's given a judicial order number ... and other judges within the district use it. In other words, when they're sentencing, they will say you will follow and abide by local judicial rule number such and such, which lays out the conditions of probation. And then it's up to the court services officer to make sure that the offender understands those things. Violation of probation conditions are considered to be a technical violation. If someone commits a new offense while on probation, it's considered to be a legal violation. Either type of violation can lead to revocation, and revocation simply means that the court is taking probation away and requiring an offender to spend the remaining time on their sentence in a jail. Most conditions also cover the major aspects of everyday life. requires offenders to cease and desist using any illicit substances. Most of the time, they're prevented even from consuming any type of alcohol. They're required to get a job. They're restricted to their home and to work, not typically allowed to be in too many public places, and they're certainly not allowed to associate with other people who are on any type of probation. So it really impacts their life on a daily basis. The people responsible for supervising or carrying out the court's order when it's been given probation are simply probation officers. There are about 2,000 adult probation agencies in the United States today. Here in our state, probation is a function of either court services or community corrections. Court services is a function of the court. A court services officer answers to the judge, is hired and employed by the judge to conduct specific services, or on higher level cases, community corrections, a function of the Department of Corrections, is employed to do that. These officers provide specific services for the court, such as pretrial assessments related to risk. They will develop criminal history worksheets that are applicable during sentencing, and they do offender supervision, sometimes during bond, most of the time while they're on probation. One of the tools that these probation officers use when first encountering someone either on bond or someone being sentenced uh, or at the very beginning of their term of probation was what's known as risk classification. This is an assessment of the offender that helps the officer determine how likely they are to reoffend and how dangerous they are to themselves and potentially to the community. How often they meet with their supervision officer or their probation officer will depend in large part upon that risk classification. These risk scores are also a critical factor at sentencing because if someone falls into the grid, the sentencing grid that we talked about previously, and they're in, say, a border box where it's simply up to the judge to decide, but they've scored as a high risk offender, more than likely they may be incarcerated at least for a period of time before they're allowed to go on probation. Just because someone's on probation does not mean that there are not legal issues that come up. When defendants are placed on probation, many of their constitutional liberties are set aside. And here you can see several cases that have been listed in our text that all deal with this issue that confirm that by accepting probation, you are voluntarily setting aside some of those constitutional rights. I'd encourage you to read those. They may or may not be cases that you want to use for your final paper. Your final paper assignment, of course, being that I'm going to ask you to review a Supreme Court case that's impactful on the entire criminal justice system. So you may want to take a high-level look at these and see if this is a case that interests you. But just because they've set aside some constitutional rights does not mean that all of their rights have been taken away. If the prosecution determines that they want to revoke the probation of an offender, there are still rights a defendant enjoys. They are still afforded counsel at revocation hearings if they choose to have it. Probable cause is the standard of proof, so even though there is a lower standard than a conviction, there's still a standard of proof that is required before someone's probation can be revoked. In many cases, they're required to pay fines. They're required to pay probation supervision fees. Failing to pay those or refusing to pay those is not an act on itself that is revocable. So how effective is probation? We've had it forever. It's been a permanent part of our system, and yet we still see our incarceration numbers climbing, and we still see our number of people placed on probation climbing. So there's an argument to be made that probation is not effective at all. We do know that most of those offenders are not first-time offenders on probation. In fact, 75% of them have a prior criminal history of some sort. What causes people to fail on probation are typically social or psychological disorders, meaning they're mentally ill, their addiction battles, if they've not been afforded an opportunity for treatment or didn't fully participate in treatment programs, addiction is still going to be an issue. Sex offenders tend to have a high revocation rate. Some people argue that that's related to the stigma associated with their conviction. Others argue that it's a problem related to a mental illness that caused them to offend in the first place. But sex offenders typically do not successfully complete probation. When probation officers are managing a caseload and are getting concerned about a client, one of the first warning flags for them is failure to show up for a designated meeting um, or a treatment session. So when they're notified that, hey, they had an appointment and they didn't make it, that's usually an indicator that something has gone wrong. And that's usually when probation officers begin to dig to see what the problem is. A blended concept um, that many courts have explored is intermediate sanctions. The benefit of these sanctions are that they save local governments money. They allow for increased control of a defendant as they go through the rehabilitation process, and it reduces overcrowding within our county jails and within our prisons. Intermediate sanctions are typically a blend of incarceration and or fines, forfeiture of property, required restitution to be paid to victims, split sentencing, meaning I'm going to ask you to spend 60 days in a county jail, and then I'm going to ask you to spend 14 months on probation. And if you successfully complete it, fine. If not, you're looking at going to the Department of Corrections. Intensive supervision probation is considered an intermediate sanction. Usually that's applied early in someone who is a first-time offender. It's not usually for repeat offenders. House arrest and electronic monitoring technologies allowed us to enable the use of geofencing to specifically monitor offenders. And so if we're limiting their travel, but we need to monitor that can occur as well. And many of those devices also detect the presence of illicit substances and alcohol and on top of GPS locations. Residential community corrections facilities in the western part of the state, we refer to these as Oxford houses. That's a brand name. These are homes, group homes, similar to that of a halfway house, except that they are fully operated and managed by offenders. The offenders living within that home have a say in who can and cannot come into the home. Interviews are conducted and the house puts it up to a vote. These offenders are obviously required to meet the conditions of their probation, but they're also required to be gainfully employed and actively participate in all the activities of the house. Many places across the state offer daytime reporting or work release. That's a county jail function, and you usually only see those in larger counties that have the jail staff to be able to apply those. That's simply serving out a sentence, but at 7 or 8 o'clock in the morning being released from jail, being allowed to go to work, come back, being searched, placed back into the jail at night for a particular period of time. Restorative justice is a concept that first began in the early 2000s and really began to gain traction during the height of the largest criticism of law enforcement. Restorative justice focuses on the fact that crime is an act against the community rather than a violation against the state, and requires that to seek justice, you have to involve all of the affected parties. The only place that this is really applicable is with person crimes. Status offenses and property crimes really don't have an impact here. Some property crimes might, but in large part, we're talking about person crimes at this part. For the offender, this requires recognition and commitment to change, recognition of the harm that they've caused, seeking forgiveness for that harm that they've caused, and a commitment to change their lives and to never act in such a way again. With the evolution of school resource officers, we've seen restorative justice practiced in the school system. This is done to avoid expulsion and suspension because statistics show that the minute a student begins to go down the suspension path or the expulsion path, the likelihood of them ever returning to school is pretty slim to none. Some community policing models involve restorative justice, but again, these are extremely low-level offenses that have very little impact on what occurs from one larger offense to the next. It's designed to head off a problem before it becomes a bigger one. Probation was relatively a quick conversation to have, simply because the text describes a lot of this at a high level, and I didn't want to go terribly that deep. However, please ensure that you've read the entire chapter. And I look forward to what we've got for the rest of the